Welcome to the Capitol Forum's 6th Antitrust Thought Leaders interview series sponsored by KL Discovery. My name is David Blattner and we're delighted to have Eric Mahr with us today. Eric is a partner at Freshfields, and from 2015 through 2017 Eric served as the Director of Litigation for the Antitrust Division. In that role he oversaw the division's antitrust enforcement actions with a focus on civil litigation and trials. So you were there during a pretty interesting period of time as far as litigation for the division. You presided over three trial wins, which is a nice record to leave with. So what do you attribute that to?
Well, I guess I should point out first that while I was fortunate to be involved in 3 trial wins, there were 4 trial wins preceding me. So it was, the record in all was 7. We've had 7 victories at trial for the division as it stands now. I attribute, I mean, of course there's a multitude of factors, but I think one of the primary factors I attribute our success to was the real partnership that we had between the political appointees under Bill Baer and his team and the career staff who have been dedicating their professional lives to antitrust enforcement for so long. Bill showed an enormous amount of trust in the staff and respect for the staff, and gave us a great deal of independence in how to pursue the actual trial. He clearly gave the directives of, here's what we want to do. Here, he made the enforcement decision, but in terms of going into trial, how to address particular witnesses, what kind of opening to do. Bill was very hands-off, as were his deputies, and they really let the staff and my group, my trial team, do the work.
Okay. So you've had three trial wins and 7 in a row. So based on that, what's your judgment about what's the best kind of evidence, the most effective kind of evidence that the division has been able to use to win at trials so frequently recently?
Well, I think the first thing that comes to mind is that there's no silver bullet, and we have had a great deal of success recently in this recent run, in particular in the 3 cases I oversaw with pre-existing business documents. Those are documents that predate the parties ever thinking about the merger and go back to a time when they were actually competing. I think those kind of documents have 2 purposes, and they both, in that they both show the unadorned or unbiased views of the business people of both the state of competition on the market and how the 2 parties relate to one another. But they also give an enormous opportunity to address credibility, which I think in trial is the #1 factor. Maintaining your own credibility and finding any opportunity to attack the other side's credibility. And using pre-existing documents that talk about, for example, what vigorous competition existed between the 2 merging parties, while the witness on the stand is now saying, oh, we never competed with the party we're now trying to acquire, is really very effective, both again to show the state of competition prior to the merger, but also to get at the credibility of that witness, which I think judges put a lot of weight on. I think economic evidence is also absolutely critical. You have to be able to marry that economic evidence to the pre-existing documents and to the testimonial evidence. But while those have been the 2 most important in the cases that I was involved in trying, I think it really depends on the judge. There were years ago, customer testimony was used quite a bit,
right.
And including in the Oracle PeopleSoft case. And Judge Bates here in the district, who was actually our judge in the Aetna Humana case, wrote a big article about how he didn't find customer testimony to be particularly enlightening, at least as to the main issue he had to decide, which were the future effects of this merger, a question which he found customers to be particularly unqualified to help him answer. So customer testimony is kind of out of vogue in antitrust, but I wouldn't put it completely away. If the facts of your case lead you to an important customer who has real world evidence of the likely future effects of the merger, I wouldn't stay away from it just because that kind of evidence is out of vogue.
Yeah, I mean, generally the division still goes out and interviews customers during the investigation. I assume they did that with these cases as well.
Absolutely. Absolutely. But when you're talking about markets like health insurance, where there are millions of people affected, bringing 15 of them who say this merger is going to hurt me, when the other side can find 15 that will say no, this merger will be great for me, is meaningless in the context of millions. And but depending on the facts of your merger, if you had one large customer, unlike in the health insurance market, one large customer who had compelling testimony, or maybe a natural experiment that showed what happened when these parties stopped competing and how prices went up, well, then I would put a lot of weight on customer testimony. But typically for now, it's pre-existing documents and economic evidence.
It's interesting because if you go back and you look at the Cisco U.S. Foods trial, the FTC used a lot of customer testimony in that case and was successful there as well. So it's, I guess it's not the case that customer testimony is never valuable. It's just that you need something more than just customer testimony.
I agree, and you have to consider the facts of your case, the kind of customer testimony you have, and your audience. Some judges are going to be more open to customer testimony. Some judges are going to be more open to economic testimony. Judge Bates, again, for example, really wrestled with nested logit models and really tried to get into the econometric evidence. I've had other judges who don't want to hear it at all and can barely stay awake. So there's not a one-size-fits-all answer to the question.
Right. Okay. So another question that comes up is when the division is deciding whether to bring a case, what's the role of worrying about whether you're going to win or lose the case in deciding whether to bring the case in the first instance?
I think that's a very interesting question, and in some ways I didn't have to wrestle with that question because I had the fortunate position for me, because it's what I like to do, is the division made the decision to bring the case and I got to take it to trial and didn't have to question whether, is this a good idea or not. But I think that the idea of litigation risk in the context of a law enforcement agency, and particularly the antitrust division, I have a hard time grappling with it because I think the whole purpose of the enforcement effort and the mandate of the division is to protect consumers. Mm-hmm. And if you're faced with conduct or a merger in which there's a belief based on the agency staff's analysis, the economist's analysis, the policymaker's analysis that consumers are going to be hurt by this behavior, I think it's incumbent upon the agency to act and enforce the law, even if that means a potential risk. The kind of litigation risk I'm used to on the private side is, well, we could lose a lot of money. So if we can settle for 10% of our potential loss, that's how you take litigation risk. But I don't see that in the same way on the government side. Now, I have to say at a personal level, one of the things when I was asked to take over as director of litigation, I was very excited about is I'm joining this very pro-enforcement agency that's going to a lot of trials. I wanted to get into a lot of trials, and it was on this 4-0 win streak. I thought, great, this is a great time to join. And as soon as I sat down at my desk with the American flag behind me and got ready to work, I realized, what have I done? I'm going to be the first. I'm going to lose. Right. I'm going to lose one of these. The regression to the mean tells us we're eventually going to lose one of these, and it's going to be me, and I'm going to be that guy. And fortunately, that didn't happen. But on a personal level, everyone thinks about it. But should it affect enforcement decisions? I don't think so.
Well, it's interesting. When you say that. I worked in the criminal side of the antitrust division, and the standard there was you had to believe that you could prove the case beyond a reasonable doubt before you even got to make a recommendation. And so there are plenty of times when you come across cases where you might think somebody had done something wrong, but you just don't think you've got really the evidence to do it. And U.S. attorneys' offices certainly have way more cases than they can ever bring, and they have to sort of pick and choose which ones to bring. And a lot of that does come down to which ones do we think we can win, which ones do we think we don't want to put the effort into because we don't think it's a good enough case. So is it your experience at the division when you were there that those sort of resource considerations and there are other cases that we could try that we might have more success with didn't factor into the decision, or should they factor into the decision?
Well, I think they necessarily have to, especially when you're talking about a U.S. attorney who's faced with 250 cases. But when we tried the health insurance cases, we were actually trying two cases combined value of around $90 billion. At the same time, in the same courthouse, and literally running into each other in the halls as we were trying these two cases. And at the same time, preparing two cases that were slated to go to trial, one in April, just months after the health insurance cases, and one in June, just a few more months after. So the division, you would think, was strained, and certainly a lot of people were working very hard during that period, but we were never at the point where the resources were such that we couldn't do what we needed to in the courtroom.
I mean, were there ever instances that came up when you were there where that was a concern, that we just don't have the resources to do this case, or that it's just going to take too much to do it?
Those were concerns, but they were concerns kind of after we decided we have to challenge these two mergers. They're going to harm consumers, and they're going to harm the health insurance markets at a time when our entire health care system is in a state of real uncertainty and flux. After we make the decision to file them, and we'd had core teams set up for both trial teams, but as you start into it and you get discovery demands from the defendants, and you start into the litigation depositions, there was always a concern about, do we have enough people? How can we move people around? But the effort that was organized under Patty Brink, who's the Director of Civil Enforcement, to bring resources from criminal, from the New York field office, from all over the division, from the civil division, also had lawyers come over. We just made it happen. So those concerns are there, but they didn't affect our ability to continue on. Okay,
good to hear. So given that we now have a vertical merger challenge with the AT&T Time Warner case, what are your thoughts generally on vertical merger litigation as opposed to the horizontal merger litigation that you oversaw when you were the Director of Litigation at the division?
Well, I'm much more, I'd say, on the spectrum of antitrust lawyers, on the focus on the facts and a focus on kind of evidence at trial more than theory. So I look at the end of the day about how to put together a case, and that involves, again, putting together a compelling story, a story of consumer harm, and the documentary evidence behind it. I think you would try it the same way in terms of preparing it for trial and bringing in compelling witnesses, compelling pre-existing documents, and economic evidence. And it seems that's how the division is structuring the case. I think that's kind of divorced from what kind of theory. I don't think you would try a case necessarily different. The legal arguments at the beginning and the end might be a little bit different, but in terms of the spade work of putting witnesses on and doing cross-examinations and bringing in pre-existing documents and getting your economic evidence lined up, I think would be very similar.
And how do you approach an industry like this, which I guess is a little bit like healthcare, that's undergoing a lot of change at the same time that you've got mergers going on? How do you account for that in the story that you're trying to tell, or the evidence that you're trying to put on, where everybody's going to be saying, well, look, things are changing very rapidly, we don't really know what's going to happen, or we can look back and see this has happened and we expect more change to happen. So how do you go about predicting the future, in a way, in cases like that where you have industries that are undergoing a lot of change while you're trying to sort of stop a merger?
Well, I think, again, at least in the cases I've seen, it comes back to the same two, I guess, ends of the spectrum. One is the pre-existing documents, the nitty-gritty evidence, the emails, that this is how the parties view the likely effects of this merger when they talked about the market and their competitors in general before they had thought about the merger. And then on the other end of the spectrum, you have some of the best economic talent in the country talking about the different models and the way they model the market and the industry to predict the competitive effects. And I think things may be changing, there's no question, and most industries are fairly dynamic, but that doesn't absolve us of the duty to make our best prediction as to the likely effects of it going forward.
Yeah, it just makes it more complicated to try and
Certainly
present
does.
a story.
And it might make it more challenging for the judge to understand, and I think that's something that the judges certainly have to wrestle with. But in terms of the approach from the litigation, I think it's similar again.
Okay. So I guess the last topic we wanted to sort of talk about is there was a long stretch in the I guess it would have been the early 2000s, where the division brought the Oracle PeopleSoft case, lost that case, and then didn't bring another case, certainly another litigated case, for quite a number of years. And then recently we've had this large uptick in the number of merger cases the division has brought, and that they've tried successfully to verdict. So what do you think going forward? Should we expect a return to fewer cases going forward, or should we continue to see the division trying more and more cases in the horizontal merger context?
Well, everything I saw while serving with the new Trump group in the front office confirmed what Principal Deputy Attorney General Andrew Finch has said many times, which is that the new administration intends to continue to vigorously enforce the antitrust laws, and I didn't see anything different there. That said, Macon Delrahim was a Deputy Attorney General back at the time that the Oracle PeopleSoft case took place in 2004. I believe he was the deputy in charge of appeals, and they decided not to appeal that case. And as you say, the Bush administration didn't bring another challenge that actually went to court for the remainder of his time in office. So I think there is one side of me that says we should really watch closely as to the results of the AT&T Time Warner trial. A win could provide them with a lot of momentum and a lot of impetus to continue to go to court. And a loss could certainly dampen their enthusiasm to go back into court again. But I think everything I've seen from Macon and Andrew and others is, and certainly from the staff, is that the division is going to continue to call them as they see them, and when that requires them to go to court to enforce the law, that they'll do so.
Okay. Eric, I want to thank you very much for talking with us today. I appreciate it.
Thank you. My pleasure.